So again, in presenting the record here, we have called Carla Culvert and 23 CR 1647. Is that you?
Yes,
ma'am. And you are here with Ms. Mantellini, your attorney and the state's attorney. You have earlier pleaded guilty to the second-degree felony of aggravated assault, causing serious bodily injury with a vehicle. And the pre-sentence report has been prepared, and the parties have no objections other than you're going to make comments, I guess.
Clarifications and what we disagree with that we don't want the judge to take as fact.
All right.
Or in other people's
all right, then it's
rendition.
Made a part of the record, subject to any rulings the court may subsequently make based upon differences of opinion.
Yes, sir.
And go ahead, the defendant may proceed.
Okay, I'll start with those three items. There are comments in the section of page 1 that begins on page 1, statements of interested parties. And of course, the interested parties have the right to express their feelings and whatever their opinions are. But there are a few things I just want to clear up. On the bottom of page 2, I think might be the first time somebody mentions that the police didn't search her car, and the parties that there at the time found her purse and it had meth in it. I don't know if they had reported to the police, and the police didn't do anything about it. But as far as this report goes, my client says that she didn't have anything, and I don't know if they found anything in that purse or anything, but I would ask the court to disregard those sorts of comments regarding an illegal substance that we don't even know if it was there or not. The second thing was it's mentioned several times about the car wreck that she was in and her boyfriend was killed. I think the probation officer included that she was also on life support. She was a passenger in that car and not the driver in that car. And I did not want the court to be misled into thinking that she had caused that accident and caused the death of the other person. And the third thing, 1 second, Your Honor, was, and a witness is going to have their perception from their vantage point, and that's why we have trials for different witnesses to take the stand and provide their perceptions of what they saw. But when one of the witnesses, her perception was that it looked like to her that my client just backed up and then just floored it intentionally to smash into the man. What we do say is that we agree that the state had sufficient evidence to find for a jury or the judge to find that that it, regardless of whether it was when she put it in reverse or was putting it back in gear, and what happened, whether the car lunged forward, you know how they sometimes do. I've experienced that myself over my driving experience, but we definitely could acknowledge that it was reckless for her to even have had her hand on a gear shift when there was a person standing in front of the car. But the perception that it looked like to somebody that it was an intentional mow down, I would ask the court to just take that as a witness's perception, but not fact, and not a found fact in this case. And that was all I had to argue about on the report.
Okay, on that last
yes,
part, the defendant entered a plea of guilty and signed this document under oath.
Yes, sir, intentionally, knowingly, and recklessly. And we do concede that it was reckless for her to do that. And believe that.
Can I finish and then you can respond? I know you're anxious to get the point in. I know what your point is going to be. But really, what this fully states is, I understand what I'm charged with. I am aware of the consequences of my plea. I am mentally competent to enter my guilty plea. I have read the charging instrument. My attorney has explained it to me. I have committed each and every element alleged.
Well, then if it is my fault that we did not put only as to reckless, then that would be on me and not on her, because I've never gone in and torn apart an indictment in the plea papers to single out a single finding. In all my years, I never found it necessary, but apparently it was necessary this time. And if it was necessary, I would ask that we be allowed to amend those plea papers to say as to reckless.
Are you asking to withdraw your plea?
No, sir. We're still believe in what we're pleading to.
What else did you want to say?
Okay, so after that, moving on from the pre-sentence report, I can tell you, and you'll have an opportunity, and she'll have an opportunity to speak with you. I know that there are lives that have been drastically changed. She's just, when she speaks to me, she's in tears almost all the time. It's not something that she's just like, well, I don't care about that, or I don't care about this. She cares about it all. And in her recollection, she did not push that gas pedal. She did not intend for that car to go forward and hit that man. And the resulting injuries are just devastating. Not only
What caused the vehicle to move forward? An act of God?
No, it sounds like to me that, you know how sometimes engines are racy and when you put it in gear, it lunges forward. That's all we can figure is maybe something like that happened. Because she says she did not jam on that gas pedal and and hit him intentionally to hurt him, or even intentionally to make a car move. It just jumped when she changed the gear, and she shouldn't have been in any gear. And that's the problem. But she is, she has hopes for being able to take this lesson and do something with her life. She wants to get her GED. She has family support. I think that the truth is, if you read the comments of probation, the evaluation, and the recommendations, I couldn't have put it any better, pointing out the valid reasons why this woman not only could benefit from probation, but maybe is the appropriate thing for her to have an opportunity to do under your supervision. There are definitely cons that he puts in here, and they are true too, but it's almost like he was trying to be painstakingly fair with, in this particular situation and with this particular defendant, that probation is just not an impossibility. It's not really a foregone conclusion that she should not have that. And she is asking for that opportunity to have that. I believe you've got some support letters. I did provide them to the state. And apparently this is, if you wanted to believe that she intentionally and knowingly crashed into that man, and that would show her to be a very violent person. But as you see, she has no violence in her history. And her family does not feel like she's a violent person. It was really bad situation, and I'm sure she could go back and take it back. She'd just take the car and walk away. But there's not going to be anything to take back.
Am I correct the way I'm reading this, that the victim was in the midst of attempting to repossess the vehicle?
That's correct, John.
Okay.
And it'd be easy to think that it's just a retaliation thing. I'm going to get you.
Why would you say that?
Because I know that's how people think. But sometimes it's not that way.
Would they think?
Well, they don't all have to think the same way, regardless of why.
Maybe it's just rational thought.
It could be, but it doesn't always have to be true. And sometimes there's an exception.
It doesn't have to be, but.
And that's what we're asking
really,
the court to recognize.
I mean, I've lived a long time myself. I mean, we live on experiences.
And I've had a car that lunged forward when I put it in gear. I know what that feels like.
When someone was trying to repossess your
vehicle? There was nobody in
front. Well, don't you see really a state of mind?
Yes.
Where there would be a motive here?
And that's why I'm saying we can't speak at the same time. Gear. Well, I'm trying to make sure that you hear me. I know,
but let me speak and then you speak, okay? It's a motive. That's obvious, right?
No, Your Honor.
You don't. Are you saying she would not have a motive if someone is trying to repossess her vehicle? She stays in the vehicle, does not cooperate with that, but puts it in a gear.
She might
and
have
moves. Can I just finish?
I thought I heard a period. I thought I heard a period. Go ahead. I'm sorry.
Don't you see that as really common sense that there would be a motive there?
Are you asking me?
Yeah.
I'm saying that, yes, I can see how that would be a first thing. But even in the probable cause affidavit, I think that the officer recognizes that
he says there's no motive. She
wasn't sure how it accelerated and whether or not intention were to harm. She was reckless. And we agree. It was reckless for her to even be in the gear position of any position of the car. And sometimes cars do lunge forward. And it could look like from somebody on the sidelines that they plowed forward. I mean, there's all kinds of variables, but in this particular instance, I believe that she is remorseful about all of the injuries and the whole event, but I believe that she was reckless in the event. But to say that she was intentionally plowing the man down, I believe that's, in this particular instance, with this particular defendant, in light of a repossession of, I think there's an opportunity for the judge to recognize maybe it wasn't an intentional act like everybody else might think from the sideline.
The victim who was present, not you,
Right.
says otherwise.
Well, and I'm sure everyone would have their opinion. Yes, sir. And their position, I can't imagine he would want to give her even an inch of grace terribly and lifelong. But I'm just asking the court to recognize it. And if she had been driving down the road and seen it and like run over him, that's one thing. But there are incidents that occur that are not the based of malice. And she believes that she did not smash on that accelerator. She did not cause that car to run into the man, and she jumped out immediately and started assisting him with his injuries and trying to put a tourniquet on it. She didn't jump out and run away. I mean, this was a very real event and not anything that she had intended. Have I correctly described everything? If I missed anything that you want me to add before we pass them. Well, the only thing is
So it did. The commission of this act.
I'm saying that she put her went into gear. I believe that's when he was lifting the hood, and she should have not ever put it in gear, and anything after that should have never happened. But that's what she has done for these injuries to this man and his the trickle down effect to his whole family. But that's what she.
Why would she have done such?
I think he wasn't. My understanding was he under the hood when you put it in gear? No. And what was your intent when you put it in gear?
It just habit when you go in reverse, automatically I put it in drive. But before
why did it in reverse? That's the question.
I was trying to keep him from opening the hood.
Okay.
But he was not.
This is going against all the evidence, and I'd ask at this time that the state will be allowed to withdraw its plea bargain agreement with the defendant. She's not responsible. No, you're not. When I withdraw the state would respectfully withdraw its plea bargain agreement with the defendant.
I would ask that the state reconsider. She is acknowledging that she put that car in gear, but she should not have had her hand on the gear shift, period. And what the ensuing events that occurred are the elements the state sought just to prove. And why, just because we are trying to make it be evident that her heart, which one was the one that that maybe if the state could prove all three of them, maybe they could. Maybe they only prove one, maybe they only prove the other. But she knows that the state could prove because of her behavior. We would have to reconsider, let her take responsibility.
No. The state would respectfully request withdrawal offer. She's telling falsehoods that I know that other witnesses all say he was under that hood whenever she started all this. She didn't just put it in one gear, she put it in two gears because she backed up with him under the hood, and then she proceeded to put it in drive and to drive forward, and she's not accepting. I understand she doesn't want to be punished, but I can't in good conscience continue with this if she's not going to accept full responsibility for what she did. And besides, the complainant in this case is already fully adamantly against the plea bargain that the state has made. And I know that since he's present in this courtroom, since he's heard this story, that he's even more so. And so is the state of Texas. So we would respectfully request to be allowed to plea bargain agreement at this time and remove that cap of 7.
Well, anything in her attorney's argument on her behalf has caused you to change your mind?
Her testify when she just said what she said, that tells me where she's at, and that's it. I'm done.
Is it? Well,
No.
the thing is, though, that's how she remembers it, and that doesn't responsibility for the entire event. The entire event, regardless of what ensued, she is taking responsibility for it.
Anything else?
No, Your Honor.
I'm going to grant the state's request. And in addition to that, the court will note in statements of interested parties that as part of the pre-sentence report, the victim is greatly dissatisfied with this plea agreement and has asked the court to reconsider and impose a lengthier term of incarceration. I cannot do that under the terms of this agreement. I'm capped no more than seven years in prison. So for that reason, well, the court is going to grant this state's motion, and also that wasn't made. The court was going to refuse to accept the plea bargain agreement based upon what the pre-sentence report provides. So that puts us back in square one. And then what we're going to do is set it for trial.
Yes, sir.
Okay. I haven't had an opportunity to discuss with her how the trial system works in our court. So I guess
our system works by law.
Well, I'd like to explain to her the law.
Yeah. And it will be set for trial, and y'all can talk and tell me if we need to take up another hearing as to representation.
Okay.
Okay.
And shall we maybe be able to do that today while we're here, or do you want it on a different day?
Whenever.
I mean,
I'm taking care of business here.
See what she wants to do.
Yeah. So I'm here. The quicker we move forward, I think would be the better for everyone. We recall cause number 23 CR 1647. And Ms. Culver, the court, just for the record here, you were before the court for sentencing. The court, well, the state of Texas requested that be withdrawn for this agreement, and the court on its own, also upon review of the file, felt like the offer that was being proposed to dispose of this case was not in the best interest of justice for all concerned. And then we, by that revocation and also that withdrawal of the offer and the revocation by the court of the plea deal, then it will be automatically set for trial unless some other disposition can be reached. Do you understand?
Yes.
All right. And Ms. Mantalini is able to represent you for trial, and nobody should be talking you out of allowing the public defenders to try cases, or else we'd all be in trouble. But you have an option here. Ms. Mantalini is competent to try cases, and it may go to trial quicker if you agreed to release her, but that's your decision. The rules of the Indigent Commission, who are strict, and they deal with us in every county every 2 years. And I've been even in front of the Indigent Commission as a whole on matters of review. So I know what they think about that. Their rules are to be followed 100%. No one can pressure you about making a decision.
And if for
And-
the record, I have not pressured her to do anything, Your Honor. I just don't want it to look like I have.
Don't let guilty
people.
conscience come out.
It's not, there is no guilt in this conscience.
So, but the Indigent Commission is going to also look at our track record and the odds. They know what is acceptable in odds of people making decisions in this regard. It would probably go to trial quicker if that's what you want. A quick disposition at trial, releasing her is a good idea for you because we can get somebody off the trial docket wheel, who are ready, willing, and able to try cases and get to it. The public defenders, like she is, have a lot of cases, and most of those, if not literally all of them, are either disposed of by a plea or they go to trial, and generally another attorney is assigned to represent them because the defendants, an accelerated trial, and I can appreciate that. What do you want to do?
I want to release him.
Okay, you want a trial quicker than what probably she would be able to prepare for it. Okay, then I'm going to grant that. The next person on the trial docket you don't get to pick them, and I don't. It's the next person, whoever's in line. I don't know who it is.
Yes, sir.
Because we have a large number of people who are competent criminal lawyers, and they're going to. It'll be the next person assigned. I will inform them of that, and then we will place it on the trial docket. And if there's an attempt to dispose of this without a trial, let me know.
Yes, sir. Thank you, Your Honor.
Anything else? I think that is it. Is there anything else on our docket this afternoon? We are in recess. Thank you. Do you have the pre-sentence report?
But there's no written to the parole board, which he thought was relevant. It's from
Okay.
I wrote a copy.
Oh, this copy for me. Okay, thank you.
It's got the report as well. And he also hand wrote a letter if she wants me to tender in the order. But either no copy because it's handwritten, but I'll let you guys review it.
That's fine. You gave me all these last time, didn't you?
All right, we now call
Those yes, I already provided those.
19-32416, the state of Texas versus Cody Caesar, who is present with his attorney, and the state's attorney is present. Mr. Franklin, you are representing this defendant, and there is a motion to revoke probation that has been filed in this case. Is that correct?
Yes, Sean.
Okay. Tell me about what y'all are doing here. There's an agreement, I think, has been reached, or no?
Yes, sir. For 4 years penitentiary time. This is a joint recommendation.
Okay. Help me out here, since logic has a lot to do with what we do. In the pre-sentence report, of course, I have so many thousands of these cases. I have to have that to review. It's showing, and it looks like I may have checked that. I think I did, but that doesn't look like one of my check marks, but nonetheless, that the defendant was in 2010 placed on probation, deferred probation for burglary of a habitation, a home. That was revoked in 2015. He gets 10 years TDC then, right? So thereafter, we put him on regular probation, and he has a motion to revoke probation that has 10 allegations of violations here. Why? What message is this court sending that you get less punishment for this committing subsequent similar crimes and failing on probation again? That bothers me.
Yes, sir, Judge.
And I want to know, I'm curious what the what the state's.
Since a number of them were urine samples within a certain amount of time, like a couple of months' time, and that the underlying offense that, or the new offense was a misdemeanor. Looking at it, I looked at his last, I think his last prison sentence, or one of his prison sentences, was 2 years and doubled it to 4. He has been in prison, I think, on serving some time on some other cases. He's been to Safety since this, I think. I can't remember when he went to Safety, but that's the reasoning behind it all. Plus the nature of that new offense was a misdemeanor. So actually it should have been a misdemeanor. It was yanking a necklace off of her neck. And I've talked to the complaining witness, and she is present in the witness room here to testify today in case the judge rejects this deal, but she's okay with it. They have children together.
Go ahead, sell it to me, because I'm not convinced.
Your Honor, we have, we
It's
provided,
just, you know, what my concern is. Yeah, everything I do here, people use, although every case has its own merits, its own circumstances, but people want to know, are you getting less punishment for continuing to commit not only crimes, but the same kind of a crime? And a home is somebody's most valuable asset. Most of us, 99%. Most valuable thing they own is a home, which is sacred. That's why burglarizing a home is more serious of a crime than burglarizing a building that's not a habitation. But he received 10 years. He knows that we're serious about this behavior. And sure enough, here we are, another burglary of a habitation.
Your Honor, this relates back to a charge in 2019. We would like to tender to the court. We've received letters today that were written to the parole board for the original offense, which details information from maybe 6 or 7 individuals as to his character. The information here that is relevant to this specific case is that Mr. Caesar is now a father. He obtained visitation rights for his children while he was incarcerated. His children are young, very young still. They were born a year and a day apart. Since that time, he has attended.
Wait. When were the children born?
What year?
2018, 2019.
We got 10 violations since they were born. All these really? These drug possessions? And you're going to hide behind children? I mean, look at that. Putting the family assault aside, which is a terrible thing in itself, no matter how minimal it is, you don't assault someone you claim to love. That's bizarre. But April, May. I mean, we're talking about methamphetamine, Xanax, marijuana, methamphetamine, marijuana. Oh, that's being a good role model for the kids?
No.
No.
Your Honor, I was going
No.
to divorce and not.
There's no excuse for that, sir. You really? You've got an excuse for taking illegal drugs, do you?
No, sir.
There is no excuse. You're supposed to be setting an example. If you use your children here, use them because you were setting a good example. I mean, I've got 10 violations while on this court's watch.
Yes, sir.
And you've got, look at this criminal history
Yes, sir.
right here.
Since I've been incarcerated,
How many felony offenses do you have?
sitting on poison.
Convictions. How many felony convictions?
This would be the
This is the 4th one. Separate act. And these last ones are manufacture of a controlled substance, illegal possession of a controlled substance, illegal possession of a controlled substance.
Yes, sir.
And this was before you were put on probation. Look at you go. You're still doing that.
Your Honor,
That's what you prefer. You've decided to dance with the devil when you have a family at home.
sir, since I've been incarcerated, I've done everything
Well,
cognitive.
you know what? Maybe incarceration keeps us all safe from you? Really? Because being free and having a family and responsibilities from a family didn't deter you from committing crimes? You're telling me, well, I've been in prison and so I'm committing crimes.
No, Your Honor, that is not our argument.
That's what it's, I mean, that was the English I had just understood.
If I may clarify, since he's been in prison, he's completed safety. He's completed about 5 or 6 classes through TDCJ, including anger management, classes on how to be a responsible parent, how to be a responsible adult. He completed every class that TDCJ offered. He's completed.
Okay.
And so we did provide those last time to the court as well, all those certificates. He is supported not only by his church, but also people that he has worked with who will testify that he has undergone changes in the last few years while in prison. And many of those did occur after he got visitation rights of his children. So the argument here today is that he has been incarcerated. He is serving time. He is accepting responsibility. He's also taken every possible step to take every class he can to educate himself, to reform himself, and to make better decisions, including safety and anger management. We would like to tender. These were letters written to the parole board on the other offense. But
what other offense?
The original 2014, 2015 charge. He was
the original burglary that he's on for right now. Probation for.
These were written a few months ago.
He's not.
2010.
No, because he was put on probation 2020, right?
Yeah.
Here.
Yes, sir. He was.
He's talking about this prior conviction of burglary where he was revoked from deferred in 2015.
So he was up for parole a few months ago, and he's asked that we provide the court with letters to the parole board because he believes they're relevant. So we'd like to tender that in evidence. I've provided copies of the state as well.
I have no objection, Chair.
All right, what is probation?
Your Honor, Mr. Cesar has actually been in custody in TDC. On May 11th of 2021, we had an administrative hearing in which Mr. Cesar was taken into custody, and he was transferred actually to GIST 7 days later on a parole violation, and he has been incarcerated.
Okay, that's on the parole violation.
Yes, sir. And that he has been in custody since that time.
Does everybody understand that's a different crime?
Yes, sir.
Yes, sir.
That's a different act.
Yes, sir.
And we're not in a position, we don't want to be in a position of, if you're going to commit a crime, commit a whole bunch of crimes because they're cheaper by the dozen. That's not the way. We're not a supermarket. You are held responsible for every violation of law, and it has its own separate punishment. Or else people would just say, if I'm going to commit a crime, I'm going to knock myself out because it all gets bundled in one package. That's not fair for each of the victims, much less the community. That means you get better treatment if you commit more wrongdoing and make more of a mess.
Your Honor, if I could continue.
You may.
Prior to Mr. Cesar's relapse in 2020, he did have the ability to perform well on probation. I will give him that credit.
Yeah.
But
okay.
Can I finish?
I want you to answer this. He was capable of it.
Yes, sir.
But yet he made a choice not to.
He did relapse. Yes, sir.
No. He made a conscious choice not to follow the rules when he understood and appreciated right from wrong.
Yes, sir. When I was home, I did buy a new house. I've started LLC. I paid off all my community service. I've never missed a visit, and I paid off all my fees.
I'm sorry, everybody's supposed to do that.
Yes, sir.
But I'm more concerned about the crimes that you're committing on top of crimes. And that's where people are concerned. The community wants to know, who gets punished? What does it take to get punished?
So,
How would you analyze then, if you were here, the defendant under this circumstance? Especially in light of he received 10 years imprisonment for the same thing prior to committing this crime. Not talking about the state jails, but the same crime. What message do we send by walking back
No, sir. Yes, sir.
responsibility?
If the court's asking what if I was in your robe,
No, everything is unique. But you know what the uniqueness is in here, in this case.
I would take into consideration Mr. Cesar's ability when he is clean and sober to do that. But obviously my recommendation would be for the revocation, and I would go also that I believe according to Odyssey, the assault case is actually set for trial next week.
What is that? What assault?
The misdemeanor.
The misdemeanor.
That's the yanking the necklace off of the complainant. That's number one in our.
I believe that's what he pled.
The complainant is whom? Is a relation?
It's the mother of his
It was
children.
the mother of his children. Yeah.
Well, we know where many of those cases end up going.
Yes, sir, we do.
I'm not even going to go into that one.
Yes,
that has the decisions. I take more. I put more weight in why they were filed in the first place and who was behind the filing in the first place, because too often we know what's happening where the defendant comes back and pleads for forgiveness. And makes everybody else feel guilty about making a complaint, which is not fair. That's generally what's happening here. Because that's the kind of case that is most often requested to be dropped of all cases filed of family assaults. Is that just unique? Is that just like we keep hitting lottery over and over again? No, it defies logic because we know it is logic. There's behind the scenes going on that causes people to feel guilty about what the real guilty person did, which is not fair to them. But I've already seen as a family man, sir, what you've shown. You had a family at home. I have a family. I can't imagine looking into my children's eyes and making conscious choices to pull stunts like this when they're at home, relying on me as a role model, as a provider, as a parent. You failed on that.
yes, sir.
Asking. Yeah, which is back in July or something, 21. Yeah, that's pretty.
Yeah, one.
We've gotten that, but we issued the NTRP warrant.
Yeah.
He was in TDC at that time, so
So-
we had the hold from 21.
July 21, probation's got emails from them saying they confirmed the detainer on him in July of 21.
So that means he's getting credit
Yes,
from 2021,
yes, sir.
which is how long now?
Get into Odyssey.
When in 2021?
July.
Would you say?
It would be July 19th is the date that we received an email from TDCJ confirming that the detainer wasn't in place on Mr. Cesar.
They didn't close it until he got here.
Is this 114 days including that detainer hold?
No, that's without it.
Okay, so we're looking at 2 years and 6 months plus 114 days,
Yes, sir. Yes.
right?
Sounds right, Judge.
Judge, I previously sent a DPS search over to Lacey because we knew there was issues with
Here,
calculations.
is this, whose is this? I've read that.
Is this, Judge, we were trying to tender it into evidence.
You want it for this hearing?
Yes, Your Honor.
Okay. Mark it as an exhibit, please. So from probation, your request, your recommendation, Ms. LeBlanc would be what?
Would be revocation.
Yeah, okay. And there's an offer for disposing of this in 4 years. For 4 years, you're close to him. What do you think? Is that?
I would consider that a fair offer compared to what the original offer was.
I don't understand. What was the original?
2.
Oh. No, the minimum. Yes. Okay, so this is defendant's exhibit is received. Eight pages made a part of the record for this hearing. And anybody else want to be heard?
No, Your Honor.
Okay. All right, I'm going, does the defendant waive formal readings of this motion to revoke probation? Can we proceed in summary?
Yes, Your Honor.
In summary, this motion, sir, and raise your right hand. Do you solemnly swear or affirm any statements you make today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Lower your hand. This motion states that on March 9th, 2020, you were sentenced to 10 years in prison, probated for 10 years in this court for burglary of a habitation. Is that true?
Yes, Your Honor.
Very interesting, just to, why that prior burglary was not included in the indictment and used as an enhancement. Does anybody know? Because that would have enhanced it to a first-degree felony, but nobody really knows.
No, sir.
I can't speculate, Judge.
Let's see.
I think because
Number 3. Let's go to number 3.
conviction.
You provided a urine sample on or about April 27th, 2021. And I guess to the probation office.
Yes, sir.
That showed benzodiazepines in your system, an illegal drug. Is that true?
Yes, sir.
4. On April 27th, 2021, it showed you provided a urine sample to the probation office, I presume, it's inferred, that showed the presence of methamphetamine in your system. Is that true?
Yes, Your Honor.
And then back in jump to May 11th, 2021, this shows a urine sample showed methamphetamine in your system. Is that true? From a urine sample?
Yes, Your Honor.
Are you pleading true? Let's just take those 3, 4, and 7. Okay. Are you pleading true to 3, 4, and 7 voluntarily? These allegations in a motion to revoke probation. You're pleading true voluntarily, and because those are true.
Yes, sir, Your Honor.
Do you understand by a plea of true, a knowing and voluntary plea of true to one or more violations of probation? Those are enough to grant a motion to revoke probation. Your probation can be revoked. In this case, you can be sentenced to no less than 2 nor more than 10 years in prison. Knowing that, do you insist on pleading true today?
Yes, Your Honor.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
An agreement is before the court where your probation would be revoked for these violations. And you would be sentenced to 4 years. Is that your understanding of the agreement?
Yes, Your Honor.
4 years in prison. If I follow that agreement, you have no right of appeal. Do you understand?
Yes, sir.
I show you what's marked as State's Exhibit 1, most importantly at the bottom. That is a waiver of all appeal if I follow this agreement. Did you sign that? And
Yes, sir.
are you standing by that?
So, Your Honor.
State's Exhibit 1 is made a part of the record for all purposes. And the agreement is that the defendant's probation would be revoked. He would be sentenced to 4 years confinement in prison. Anything else to add? State's Exhibit 1's made a part of the record. Anything to add by anybody?
No.
Okay. If not, I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater, as allegations 3, 4, and 7 have been proven true beyond reasonable doubt, much less preponderance of the evidence. Your regular probation is revoked. You are now hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years as the agreements provided for. You know, Mr. Caesar, you know what my feelings are about all of this. And you can't play both sides of the fence. A family is all, you go all in for the family. You go all in for the rules. If you consider yourself a father and a parent and a husband, and you claim that you love and care for those families, you just don't talk about it. You have to show it. And you show it by the choices you make and the actions you take. I'm looking at a page full of mistakes that you made after you have made mistakes in the past. You don't use your family who rely on you as a lifeline to get yourself out of trouble. You have to be the one setting the example, Mr. Head of the family.
Sir.
Or do them a favor, get out of their life. If you're going to be in their life, be the best person you can be to make them make the wisest choices so that they are successful in life. But I know this, children are going to follow what their parents do.
Yes, sir.
And it's just not your life. When you became a parent, you brought other souls to your chest. And the direction you head is going to impact their life and is going to affect and influence their life.
So,
why don't you lead in the right direction so that they're not only proud of you, but they're proud of themselves because they can say, my dad made mistakes, he fixed those, and there's not a better person on this planet than him. You're going to have to earn that every day. Can you do that?
yes, sir.
We'll go and get it done.
Thanks.
Okay. Anything else?
No.
That's all.